Now recognizes former magistrate Hank Johnson, who is also a subcommittee chairman in the Judiciary.
I'm sorry. Thank you, Mr. Chairman, and I want to thank you for and commend you for having this hearing on this very important issue right now. Who were the parties to the settlement agreement? In other words, who sued whom?
We sued him down there.
Us,
yes.
Okay. Who sued whom?
We brought the Authors Guild brought the first lawsuit, the class action lawsuit, in September of 2005. 5 publishers then filed suit a month later in a non-class action lawsuit, also against Google, basically over the same set of facts.
Mm-hmm. Was there any entity with the interests of the orphan works owners a party to the legislation? A party to the litigation, I'm sorry.
Right. Well, I mean, orphan works are works for which you can't find...
I understand.
Yeah.
I understand.
Okay.
So it's totally impossible to have a group that represents the orphan works owners, but perhaps there could be some entity set up that would be like a fiduciary, a guardian ad litem, if you will, for the orphan works owners. And that was not done in this litigation. And what troubles me about the settlement is what gets included within the scope of the agreement. Of course, settlements are a part of ordinary litigation. I love settlements myself, and they must be fair, of course, and they generally only apply to the parties. This settlement agreement, it seems that it's going to bind orphan works rights holders. It's not clear to me that copyright owners of both orphan works were adequately represented. In fact, it appears that they were not represented in the plaintiff's class. As chairman of the Courts and Competition Policy Subcommittee, I'm also particularly sensitive to the antitrust implications of the settlement. That's why I am troubled by the exclusive access Google will have to orphan works. It'll be like the gatekeeper. Why should Google be the only entity permitted to sell access to orphan works? And I guess I'll ask Mr. Balto that question.
It's important to recognize a couple things. First, the number of orphan works is extremely limited.
Well, yeah, I mean, it doesn't matter whether or not it's 1 or 10,000.
Well, I
would submit to you there's probably almost infinite number of orphan works out there.
My testimony in my paper cites different things that suggest it's relatively modest, less than 1 million works. Second, the problem with orphan works, I mean, I think it's really important. One is more than none. The problems that people are posing on orphan works would just prevent orphan works from ever being in the public, ever being accessible. And you need to overcome them, and I think this is one sound approach for being able to overcome them.
Well, I'm set up this process where Google is the gatekeeper, you think is the way to settle this universally? When I say universally, in terms of U.S. law?
Representative, I put myself in the shoes of, I used to be an antitrust enforcer, did that for over 15 years. I thought, how would I solve this problem? And I think what they've done is, these people have gotten really sound antitrust advice. This is a sound approach for dealing with this issue. So there is not some kind of critical gatekeeper role. They've tried to permit in as many fashions as possible for these orphan works to be accessible. Again, I tend to think it's not that significant an advantage.
Well, there are those who would thoroughly disagree with you, and
by the way,
I'd be one of those.
Oh, but by the way, there's this great brief by these 30 antitrust law professors, and 30 is more than 2. And they went and analyzed the settlement at length and found that the exclusivity, it's really non-exclusive, and I commend that analysis to you.
Well, let me ask Mr. Professor Picker for his response. Why should Google be the only entity permitted to sell access to orphan works?
I guess I'd start where you started, which was the question of how are the orphan works represented in the case. So in many class actions or in bankruptcy settings where you've got, for example, in tort situations, you've got current tort victims and then you've got the possibility of future tort victims, it's pretty routine to appoint a separate representative, just as you said, as guardian ad litem for those future claimants. And so a very natural approach here would have been to appoint an independent representative as a guardian ad litem for the orphan works. Had that been done, God only knows exactly what kind of licensing scheme would have emerged and whether that licensing scheme would have involved an exclusive license or would have involved a broad license. To go back to what Google has said, right, Google is good on this. They're very clear. They favor broad licensing access to the orphan works, and I agree with them.
Where would they get the license from?
Only from the government. Only from you or from the courts.
So in other words, you're going to bind the United States government, the legislative branch, to the terms of a settlement that that is in the judicial branch.
I actually think that's a tricky question. That goes back to a little bit to Congressman Sherman's question, which is the interrelationship that he posed to Mr. Drummond, which is the interrelationship between the settlement and then a subsequent legislation, and the extent to which you can overturn that settlement in the legislation. I don't know the answer to that. I think that's an interesting. I love to write about that kind of question, so I'm excited. Well, I think it's hard.
I would pose to you that the legislative branch of government is responsible for policy.
I agree.
And you hear a lot of people talking about legislating from the bench. This would be a classic case, and that's why I'm happy that you're holding this hearing today, Chairman Conyers, because I think that it does give the parties to the litigation and others kind of a bird's eye view of the various issues that are involved here. And also, I doubt whether or not Judge Chin watches C-SPAN, but perhaps in a moment of pleasure he might. And I know judges are not supposed to look at outside information in making their decisions, but their decisions are based on their experience, their living, their experience. And so perhaps this hearing could be of some interest to the judge. I'm not saying somebody here should pull his coattail and tell him to watch this later on tonight on C-SPAN. But sweeping scope of this settlement and the significant limitations it places on rights holders who did not opt out, it seems to me that the settlement is coming very close to whittling away the powers of the United States Congress.